Hello, and thank you for registering for Susan Geffen's Medi-Cal Planning presentation. My name is Martha Patterson, and I'm the elder law attorney sponsoring this important presentation on Medi-Cal planning and asset protection. Why am I sponsoring Susan Geffen's presentation? Because this subject is so important, and Susan does a great job of explaining how Medi-Cal planning works and how to avoid making mistakes in the process. Another reason I'm sponsoring this presentation is because this topic is so vast and complicated. Some of you may have further questions, and I want to be that resource for you.
Hi, I'm Susan Geffen. Today we'll be discussing Medi-Cal and asset protection. This webinar is for adult children of elderly parents, spouses, and professionals who assist elderly adults with finding long-term care and understanding its financing through Medi-Cal. Before we get started, let me tell you a little bit about myself. I have a degree in speech pathology and audiology. I'm an elder law attorney. I taught elder law at Loyola Law School. I have a master's degree in gerontology from USC, and I wrote a book about nursing homes. I tell you this so that you understand my passion for this subject. Mostly, I have a passion for educating people about how to find and finance long-term care. That is why over 30,000 people just like you have come to my seminars called Raising Up Your Parents. Why am I doing this webinar? To help you understand this incredibly important government program. I want to help you avoid making mistakes. It is really important that you don't try this on your own. I want you to understand how to protect your assets from Medi-Cal recovery should you avail yourself of Medi-Cal. I want to be able to help people, as many people as I possibly can, in a convenient format, even possibly from the comfort of your own home. While there are other options other than Medi-Cal for long-term care, I'm going to be speaking about that today only. And please remember that Medi-Cal for long-term care is different than community-based Medi-Cal, which I will not be talking about today. Medi-Cal for long-term care only covers nursing home expenses. If you make a mistake, you don't follow the rules, you could be liable for nursing home costs, which typically run about $9,000 to $12,000 per month. More importantly is if you try to gain eligibility and you make a mistake, the person who needs the care will also be out of money to be able to pay for private care. So they won't be eligible for Medi-Cal because a mistake has been made in the process and the application will be rejected. But if that person has wrongfully just given away assets thinking that that's okay, they don't have the assets then either to pay for private care. And that is a really, really, really bad result. So let's get started. To begin, let's look at some real life examples of how I've helped some families. Let's look at the first example. In this first example, I helped a Korean son get his father onto Medi-Cal so his mother, the stay-at-home spouse, which we will call the community spouse, would not have to pay $12,000 a month out of their savings. Had she not known of this benefit, she would have been out of all of her resources in 15 months. She only got $600 a month in her own income from Social Security. Her husband got $2,400 a month. All of that would have also gone for his care. As you will see after going through this webinar, their family easily qualified for benefits, and my client's mother was able to keep all of her husband's income but $35. This should have been an easy case to qualify, but because there was a Korean pension involved, the eligibility worker was too thrown off and denied their case initially. The good news is that while an appeal is pending, and for however long that appeal takes, the facility does not have the right to seek private pay, and it is illegal to evict the resident. Ultimately, I found a good supervisor, and the application went through. Now let's look at the second example. As you will learn, an applicant can only have finite resources to qualify, and there is a limit on how much of an institutionalized individual's income can be allocated to a stay-at-home spouse. In one case, I helped the community spouse, that is the non-institutionalized spouse or the stay-at-home spouse, keep not only her home in Hermosa Beach, but 2 other commercial properties that would have disqualified him from eligibility. It would have put them over the property limit. She needed these properties to generate income for her, as she herself was going through chemotherapy and could not work. Now let's look at the third example, where it starts out with single Medi-Cal recipient able to sell house before institutionalization. In this third example, my client was very, very proactive so that he could afford assisted living but not be over the property limits in the future if he needed a nursing home. He put his house in an irrevocable trust. When he sold it, the money went into an irrevocable trust account. The $1 million did not keep him from qualifying, as assets held by this type of trust do not count as an available resource. These are very restrictive to the property owner, and that is why I caution using them, that is irrevocable trusts, except for when it truly makes sense and the individual agreeing to do this with his or her property is very lucid. In the fourth example, where it says claim for estate recovery overturned, I was not involved in getting Medi-Cal for the parent, but I was involved in making sure that the $90,000 bill that was amassed did not have to get paid back because the decedent left a disabled adult child. This is what we call an exception to estate recovery. Here's what I'm going to teach you right now. I'm going to break Medi-Cal down into 3 components. These are eligibility, share of cost, and estate recovery. Eligibility simply means, do I qualify? Share of cost means, assume I qualify. How much of my spouse's income will go to the nursing home? And how much can I keep? Now, for a single person, he or she just keeps $35 as a personal needs allowance. I know, you can't even buy a tube of toothpaste for that anymore. The third prong answers the question of how much will my family owe after I die to pay the state back for all of the money it spent on my care. This is called estate recovery. The last thing we will discuss is how someone who is already on Medi-Cal can lose their benefits if they receive a lump sum inheritance or get a personal injury award or settlement. So let's roll up our sleeves and discuss eligibility. How do you know if you can even qualify? It is like Monopoly. You cannot play the game until after you pass go. If you have too much money or too many assets, you cannot pass go. So, what is too much money? A single person can have only $2,000 in non-exempt or unavailable assets. If married, the spouse, again called the community spouse, can have $126,000 basically in exempt or unavailable assets. What are exempt assets? And when I say exempt, that means that they do not count towards the $2,000 that an individual can only have or the $126,000 that a couple can have. Your home is an exempt asset if you live in that home. Period. End of story. Doesn't count. Even if your home is worth $1 million, it still doesn't count towards that $126,000 limitation, or for a single person, that $2,000 limitation. Now that has an asterisk by it. And the reason that it has an asterisk by it is that I want you to understand that if that house is sold and that $1 million is converted into cash, you no longer have a $1 million exempt asset. That $1 million will count against you. Again, as long as you live in your home, that asset is exempt, even if it's $5 million in California. Other real property can also be exempt. You see some asterisks there, and that is because that requires a very sophisticated analysis, which needs to be done by somebody with experience, and most notably an elder law attorney. Other exempt assets are household goods and personal effects and jewelry. You can also have one motor vehicle. That could be a $300,000 vintage Rolls Royce. As long as that's your car, that vehicle is exempt. But if you have that vehicle and you have another vehicle, the other vehicle won't be exempt. So if it's a Lexus, for example, that's $70,000 that's going to go towards your $126,000 as a couple. Or if you're an individual with two cars and it brings you over that $2,000, then you are not going to qualify. Another exempt asset would be a whole life insurance policy with a face value of $1,500 or less, or a term life insurance policy. Burial plots, no matter how much they're worth, are also considered exempt assets. So as you can see, there are a lot of exempt assets. There's also IRAs. Did you know that you can have $1 million in an IRA and that will not count against eligibility? The reason is because that is an asset that you can't readily liquidate without having very serious tax consequences. Now, the reason I have asterisks there is because you have to be taking the required minimum distributions in order for that IRA or any IRA to be considered exempt for purposes of Medi-Cal eligibility. There are also products called Medi-Cal compliant annuities. These are very complicated products, and I do not recommend anybody purchasing one of these in order to become eligible for Medi-Cal unless you get very serious counseling from somebody who understands what a Medi-Cal compliant annuity is. Now, we were just talking about exempt assets. What is not counted for purposes of Medi-Cal eligibility? And what we're talking about is when you fill out that application, you cannot have more than $126,000 in exempt assets if you're a couple, or $2,000 if you are an individual. You can have other assets as long as they're deemed unavailable. So we were talking about exempt assets. And we talked about the fact that if you have two homes, one of which you're not living in, that other house will be counted towards eligibility, and quite frankly will probably in most instances keep you from being eligible unless you employ some strategies. But what happens if you have your house for sale? As long as you're making a concerted effort to sell your house, the second home, and you can demonstrate that, that will be considered unavailable for purposes of eligibility, and you can still be eligible as long as you don't go over that $2,000 or $126,000. Now, some people have second homes or commercial property or whatever the case might be, some type of real property held in a joint ownership, either tenants in common or joint tenants. If the joint tenant or the tenant in common refuses to liquidate that property, it is considered unavailable and it won't count towards eligibility. If you have an individual who has a lot of assets, but that individual never did any estate planning and there is no power of attorney, in other words, an individual who can access all of the assets, where the Medi-Cal applicant is mentally incompetent, all of that individual's assets will be considered unavailable, and it really doesn't matter how much that person has. I am not advocating for people not to have their legal documents in place, but some people just fail to do that. And in the case where there's no pre-planning, there's no power of attorney, and there's a lot of assets, those assets won't count towards eligibility because the incapacitated person can't access them to sell them and convert those assets into cash. Also, another unavailable asset is a home with no equity. What happens if you have a home whose value is below $126,000 because it is highly leveraged and its fair market value or its assessed value, which we take either the fair market value or the assessed value, whichever is lower, bears out the fact that there's no equity in the property or no equity in the asset. It doesn't matter if you have another asset at that point because it doesn't have equity, so it can't count against you for eligibility. Now, unavailable assets can become available. And how can an unavailable asset become available? Well, what happens if the house sells? The second home sells. That house now becomes available. And when a redetermination comes up, if you haven't done something creative with the proceeds of those sales, then there will be ineligibility again. So you can see that an unavailable asset can become available. And you always have to keep analyzing what's going on once you're on Medi-Cal because there will be a redetermination coming down the pike. Now, what happens if you go into a nursing home, you're eligible for Medi-Cal, and you're not quote unquote living in your home anymore? Because remember I said the house that you live in. Well, on the application, you have an opportunity to let the department know that you intend to return home. And I know it sounds weird because how can somebody who's in a nursing home, who's very much mentally incapacitated and has to stay in the nursing home, intend to return home? But it really doesn't matter because it's a subjective intent, not an objective intent. So if you are filling out the application yourself, you have to make sure that you check the box off that the Medi-Cal applicant intends to return home. Also, even if you didn't check that box off, if your spouse or a child under 21 or a dependent relative lives there, then the house will continue to remain exempt. And we've already talked about the required minimum distribution for an IRA. Please be careful that you're only taking the required minimum distribution out, because if you take more than that out, then that could be considered income, which will increase share of cost, or it can bring you over the limit for eligibility if you take out a big lump sum and keep it in the checking account. So that can become a little bit tricky. Okay, so now let's talk about some hypothetical examples of eligibility. So a couple has a home worth $3 million, a Lexus worth $70,000, and each has an IRA worth $1 million, and they have $120,000 in the bank. Now, I can't see you raising your hand, so I'm not going to say raise your hand if you think they qualify, but think to yourself, after what I've told you, can that couple qualify? If you add all of that up, it equals $4,190,000. And remember, they can only have, and I'm rounding this down a little bit, $126,000. So again, I ask you, can one of the spouses qualify for Medi-Cal if he or she needed to? Well, the answer is yes. Why? Because the IRA is exempt as long as you're taking the minimum required distribution. Well, what if you're too young to take that distribution? What if you're too young? You're not 70 and a half. You'll need to call the administrator and ask that a distribution nonetheless be made. The community spouse need not be taking these distributions in order for the institutionalized spouse to qualify. Okay? It's only the IRA for the person who is applying for Medi-Cal. Now, let's go to the next sample. A single man has $10,000 in the bank, 2 cars each worth $7,000, an IRA worth $200,000. Will he qualify? I'm going to let you look at the slide again and think about what you've learned so far. Remember, he can't have more than $2,000. This is not a trick question. He cannot qualify because he can't have more than $2,000, period. Here, while he has an IRA, and if he is taking distributions, that is exempt. But he can only have 1 car. Here, because his other car is worth $7,000 and he has $10,000 in the bank, he does not qualify. Now, let's go to the next sample. A couple has a home worth $2 million, a whole life policy worth $400,000, no car, $20,000 in the bank. Does this couple qualify? No. The couple does not qualify because of their whole life policy. Let's look at 4. A single man has 1 home that he lives in, a vacation home, and $2,000 in the bank, and makes $8,000 a month. This man does not qualify because he has 2 homes. His monthly income has no bearing on eligibility unless it accumulates to bring him over $2,000 a month in cash. This was kind of a trick question, and I threw in the income to make a point. And that is, again, that income has nothing to do with eligibility. I have a lot of people who come into my office and argue with me that there cannot be eligibility because so-and-so makes so much money. It is just not true. Let's look at number 5. A couple each have $100,000 in IRAs. The wife makes $8,000 a month and the husband makes $4,000 a month. And they have a home worth $2 million. Will the spouse here qualify? Yes, because income, again, has nothing to do with qualifying. I want to let you know that just in case both people in the marriage need to go on long-term care Medi-Cal, that limit, the property limit in that case is $3,000. That rarely happens, but sometimes it does, so you should know that. Let's be clear. Just because some of these examples result in no qualification, that does not mean that there cannot be qualification. And that is why many people hire me. Again, please don't try any of this stuff on your own. Moving on to the next slide. This slide shows one strategy to become eligible. However, please understand that this is not legal advice, and this can cause more trouble if it's not done right. Many people come into my office and ask me what a look-back period is, and some argue that it is 60 months because they read that on the internet. Now, I can't really blame them for thinking that because it's confusing. In every other state, we call the program that is similar to our Medi-Cal program Medicaid. And there's many, many articles on the internet about Medicaid and the 60-month look-back period. But we're in California. We call our program Medi-Cal, and our look-back period, which we'll discuss what that is in a minute, but our look-back period is 30 months. So what is a look-back period? The look-back period relates to how long one will be ineligible for Medi-Cal because they gave a non-exempt asset away for less than fair market value. So let's say that you had a second home and you decided to just gift that house away so that you would think, oh, I only have one house now, the house I live in, yay, I'll be eligible. It doesn't work that way. Whatever the fair market value is of that gift will be attributed to you for eligibility purposes, and that would be a huge mistake. Not to mention the other mistakes that we'll go over if you just gift away assets like that have tax implications, but it would create a huge period of ineligibility. Remember, the department is looking to see if you have money to pay privately. So if you've given away money or assets that you could have liquidated to pay for care, they'll make you wait until you would have otherwise qualified. Here in California, the state will see because you must disclose it. They will know how much you gave away. They will take that amount and divide it by the average private pay rate as determined by the state, and that number will equal the number of months of ineligibility, or the number of months you must wait until you can apply and be eligible. So this is how it works. If you give away $100,000 and divide that $100,000 by $9,337, which is the average private pay rate in 2019, you'll see on your calculator that $100,000 divided by 9,337 is around 10. That would mean that there would be 10 months of ineligibility from the date of the gift, and this can be very dangerous. What if a month after the gift was given, the individual who made the gift needs care? They no longer have the money, they don't have the $100,000 anymore, and that person will not qualify for Medi-Cal. What does that person do? They're going to need care, and there's no money anymore because it was gifted away, and they will not qualify for Medi-Cal. So you can see why you shouldn't do this on your own. An elder law attorney such as myself has had a lot of training, many years of training with winning strategies. You do not want to do this by yourself. So, looking at the next slide, you can always gift an exempt asset without implicating the look back, but be very careful because gifts of real property may have severe tax implications, such as an increase in the property taxes, and more importantly, from my perspective, an increase in capital gains taxes upon the sale that could have been avoided if the person you're transferring the house to is a child. Also, you have to be very careful of being accused of elder abuse. You can transfer any amount of assets at any time to a blind or disabled child of any age, though you need to be careful when you have a child who is receiving SSI benefits so as not to destroy those benefits. Okay, so now let's talk about another eligibility strategy. It's called spend down. Nothing prohibits spending money on medical bills, debts, mortgages, and loans, or other legitimate expenses. These are not gifts, and you are not giving away assets for less than fair market value. So, we've talked about gifting and we've talked about spend down. Now, let's talk about, conversion. You can convert the non-exempt resources into exempt or unavailable assets. For example, by purchasing a new home or a car, or purchasing burial plots or funeral plans, and so on. You can also fix up the residence by replacing the roof, putting in new carpets, etc. So, eligibility is based on a snapshot evaluation based on qualifying one day in the month. That means if you have too much money on the 20th day of the month, as long as by the last day you do not, eligibility can be established. In fact, Medi-Cal can go back 3 months from the date of the application, and if there was eligibility then and there was institutionalization, it will pay for that institutionalization retroactively. Every year there is an annual review of the institutionalized person's assets to maintain eligibility. This is called reconsideration. Some people inherit money or win the lottery or get a settlement or a judgment that can impact eligibility. Just because you originally qualified does not mean that it is guaranteed lifetime benefits. If you do have a positive financial change, there is still planning that can be done with your new income or assets, but you cannot wait. Now let's move on to a completely different topic. This is what I call the second prong of my analysis. My first prong was eligibility. My second prong is share of costs, which is what we're going to discuss now. The third prong is estate recovery, which is the last thing that we'll discuss. The share of cost refers to how much of the institutionalized individual's income must go to the nursing home before Medi-Cal will pay the difference. For a single person, all of an individual's income except for a $35 personal needs allowance will go to the nursing home. That means that if the institutionalized person's income is $4,000 a month, the nursing home will get to keep $3,955. The institutionalized person can keep $35. If the monthly cost of care at the home is $9,000, the state, the Medi-Cal program for which that person applied, will pay $5,045. So what is all of this? What does all of this mean? It means that you are going to be responsible for paying a portion of your nursing home bill if you have the income to support that. And the difference, which you do not have, will be paid for by the state. Sometimes monthly medical premiums can also be deducted before the share of cost is determined, such as your Medicare Part B premium. Other deductions can also be made depending on the circumstances. For example, under a legal settlement called Hunt versus Kaiser, recipients may use old unpaid medical bills for which the beneficiary is still legally responsible to reduce the monthly Medi-Cal share of cost. Some original documentation showing the billing statement that there's an outstanding balance should be provided to the county eligibility worker. The share of cost will be adjusted to reflect the cost of the outstanding balance, which could, for example, mean no share of cost until the old unpaid bills are paid off. This is not automatic and should be discussed with the eligibility worker upon application for Medi-Cal. And then there's another case that I briefly want to discuss, and that's Johnson versus Rank. Under that case, recipients may use their share of costs to pay for medically necessary supplies, equipment, or services not covered under the Medi-Cal program. A current physician's prescription is necessary and must be put in the recipient's record at the facility. This prescription must be a part of the physician's plan of care. After a copy of the prescription and the bill is presented to the facility will deduct the cost from that month's share of cost and bill the resident for the remaining share of cost. When talking about the share of cost and married couples, California law allows the community spouse, that's the one that's not in the nursing home, to retain a maximum monthly maintenance needs allowance. And you'll usually see this as the MMNA. The current for 2019 is $31.61. That's $3,161. So what does this mean? It means that if the community spouse only has $500 in income and counts on her husband's income, the eligibility worker will allocate $2,661 of her husband's income to her. What if the community spouse needs more than $3,161 to live on? You can increase the MMNA, that's what I'm going to call the MMNA at this point, to allow community spouses to have all of the institutionalized spouse's income, or you can increase the community spouse resource allowance to allow the spouse to keep otherwise non-exempt property to generate more income. These require a court hearing or an administrative hearing. Finally, we are now at the third prong of my Medi-Cal analysis, estate recovery, as this slide shows. When a Medi-Cal recipient dies, the state can seek repayment for the cost of certain services received that were paid for by Medi-Cal. After the Medi-Cal recipient dies, the state will send the heirs or survivors an estate recovery claim asking for payment for the amount of Medi-Cal benefits paid on behalf of the deceased individual. The state does not put a lien on the home, and the state does not take away the home. The state will, however, try to collect, and if you cannot get the claim waived and still cannot afford to pay, the state might negotiate a voluntary lien. Estate recovery is limited to a probate estate, which is assets distributed through a will or where there is no will, no beneficiary designation on an asset, or no joint ownership. What is not a probate estate? And any assets that you have in a living trust, joint tenancies, joint accounts, manufactured homes and mobile homes, or where the amount in an estate can be collected by a small estate affidavit. So to say this in really simple layman's terms, if there are assets when a Medi-Cal recipient dies that cannot be distributed through a trust or through some type of beneficiary designation, but have to be distributed upon an order of the court, those assets that have to be distributed upon an order of a court through a probate process will be subject to recovery. So as you can see, there are other exceptions to estate recovery. There is the homestead of modest value, a home whose fair market value is 50% or less of the average price of the homes in the county where the homestead is located as of the date of the decedent's death. So this is a new, what we call hardship waiver. And if the waiver applicant can prove that there is a homestead of modest value, the state is required to waive the claim. Also, if a Medi-Cal recipient is survived by a minor child under the age of 21, the state cannot recover, and the claim is forever barred. Finally, if the Medi-Cal recipient is survived by a disabled child of any age as of the date of the notice of the Medi-Cal recovery claim, the state cannot recover, and the claim is forever barred. The child does not need to be living with the Medi-Cal recipient or be an heir to the estate. As you can see, Medi-Cal planning and asset protection can be very complicated. With the average nursing home cost of $9,000 to $12,000 per month every year, making mistakes can be very costly.